So, question for you, Mr. Mays. You've got two files up today.
I do.
The Trombley matter, I just saw the paperwork today. It was buried in my very, very large stack of Huron misdemeanor files.
Okay.
So I'm assuming your legal arguments are the same in both your files. Is there anything factually different in the two files?
Ms. Trombley's is just a couple of days before the DataMasters were taken out of service, whereas Mr. Dickeroff's is in October.
Okay, all right. So, I mean, the fact that I haven't had a chance to read that stack of documents probably isn't going to change anything.
It's
okay.
Identical as our motions.
And I see our prosecutor is with us. So I've got Kulcharski and Dickeroff and Trombley in the waiting room. So I'm going to bring them all in.
Sure.
Thank you, Judge. Hello, William.
Hey, Murray.
I'm just going to make it run now.
Yeah, that's fine.
Thank you.
All right, Ms. Trombley's connected. Mr. Puchalski, you're connected?
Yes, sir. Yes, Your Honor.
Awesome. And Mr. Dickeroff just came in, got connected.
Yes, sir.
All right, attorneys, how about appearances?
Judge, are you recording?
Not if you are.
I'm not the host anymore. I can't tell.
It's still recording. Yeah, it's still recording.
Because
I thought that's what you had your record out here going for.
well, this is just for both.
Yeah, it's on. It's recording.
Okay, thank you.
Appearances, please.
Hello, Your Honor. Murray Duncan appearing on behalf of the defendant, Bradley Puchalski.
And good afternoon, Your Honor. William Mays on behalf of Ms. Trombley and Mr. Dickeroff.
Your Honor, Caitlin Foley-Carter on behalf of the people of Huron Township.
All right, good afternoon, all. Hold on just a minute.
I gave you the wrong one. That's the official one. Half down, and he says he needs to launch right away.
Do it.
And Shannon says we're good for the half check.
Do it.
That's the gate.
Yep. Yep. Fill me in later about that molding. Okay. All right, I'm ready to go.
Judge, I thought Rob Young was going to be here.
He should be.
Yeah. I talked to him yesterday, and he said
He tried to call me at 1 o'clock while I was doing an arraignment, but he did not leave a message.
All right. I believe the Huron Township prosecutor is making the argument based on what Mr. Young told me, though.
Your Honor, it was my understanding that we were picking witnesses today.
Picking witnesses?
That's correct, Your Honor. Maybe I can help move this along. We filed our motion to suppress the DataMasters in these two respective cases. The Huron Township prosecutors filed a response to that. I'm prepared to argue preliminarily that her response brief is not correct legally speaking, but this was scheduled with Paula and coordinated to be a preliminary hearing to select witnesses so that we could talk about the issues. But the prosecutor's response seems to indicate that no evidentiary hearing is required. But I agree with her that an evidentiary hearing is required. There's a massive amount of information that the prosecutor needs to turn over to the defense relative to this case. And if she intends to call Mark Fondren from the Michigan State Police to argue, then there's even more information that needs to be disclosed.
All right, well, this is the first time
I'll let her speak for herself.
And I'm a little bit confused as to why do you need me to determine who your witnesses are?
This was just so that we could discuss because this will take a long time. There's going to have to be experts for the prosecution as well as experts for the defense. I was going to propose that we do those on different days. But I don't want to speak for the prosecutor. I'll let her.
That ain't gonna happen. I'm gonna give you 1 day at most, 1 day and 1 day only.
Okay.
So, and once again, I don't understand why I'm involved with you determining who your witnesses are. Generally, the way it happens is you contact the court, let us know how many witnesses you got, and I'll set scheduling.
Okay.
So do you need my input to determine how many bodies you need?
No, Judge. No, what I need is
Okay.
disclosure of this information from the prosecutor because all I have is her motion response. I don't have any of the discovery.
All right, so you need some discovery before you can make a determination how many defense witnesses you need.
I generally know who my witnesses are going to be, but I need that information to provide to my experts.
All right, well, then that gets me right back to my original statement is why am I having a conversation about witnesses? Tell me how many witnesses you've got, Mr. Mays. Ms. Foley-Carter, tell me how many witnesses she's got, and then I can figure out scheduling. And then in the meantime, if I have to hear a motion about discovery because you guys can't play well together, then I'll get involved in that.
Sure, sure.
All
I
right,
have
so
at
how many
least,
bodies? Go ahead.
I have at least
How many
one
bodies?
expert, but that is in response after the prosecution presents hers.
Correct. All right. Ms. Foley-Carter, how many witnesses?
3 per person, Your Honor.
So it's a different set of 3 for the 2 files?
The
Or the 3
OIC,
files?
the OIC will be different.
All right. So total, how many bodies you got?
3.
All right. So we got 4 witnesses total.
Correct.
Okay, so let's talk about discovery. Do you not think Mr. Mays is entitled to some of the stuff he's asking for? Or you just literally haven't had a chance to get it to him?
I do not even know what he's asked for, Your Honor.
Oh, well, that's easy. Mr. Mays, what do you want that you don't have?
Yeah, Judge. Well, as indicated in my motion, Attorney Dave Rudoy submitted a FOIA request several months ago. It took the Michigan State Police a few months to compile that. I think he spent a total of almost $2,000 to get that information. There's been a number of evidentiary hearings regarding this particular issue. Traverse City, Oakland, 2 in Oakland County, 1 over in Washtenaw County. Every time that an evidentiary hearing takes place, the defense bar finds out that there's more information that has not been disclosed by the Michigan State Police. At the last hearing that I sat in on, there were a number of text messages that Mr. Fondren had shared with other people involving this issue. And I mean, it's just, there's a massive amount of information. If the prosecutor is not talking to Mr. Fondren or isn't coordinating with the Michigan State Police to be able to address this issue, then that's where the problem is. I do have a lot of information in my office, of course, that I've collected from different cases, but I need to know what the prosecutor is going to present in this case. And if she doesn't intend to present that information or have anybody substitute for the 120-day information that's absent. And Judge, I'll note from a preliminary review of the prosecutor's motion, I don't even think that she's aware that Huron Township is one of the jurisdictions that was looked at by the Michigan State Police regarding some of the failures of the 120-day certifications. I printed out what I had received from Huron Township, which is a log showing that the DataMaster was purportedly working correctly, and a ticket that indicates it's handwritten by the records clerk down in Huron Township, 120-day check. That is signed by Andrew Clark. It doesn't indicate any problems. On the log book that's kept at the police department, it indicates this 120-day check was done, and it indicates no problems. And yet there was a problem. There was a problem with Mr. Clark's performance of that 120-day certification. He didn't do the test correctly. And it doesn't appear to me that the Huron Township prosecutor is even aware of this or that it's contained in these Michigan State Police documents. I can't.
Hold on just a minute, because I think I know what Ms. Foley-Clark's going to say, but go ahead.
Your Honor, I cannot disclose any discovery that I don't have, first off. And as I understand, the discovery is reciprocal. So anything that defense counsel has, I should also have, which I did not receive. But it's my understanding that if you've read my brief, then you know that I intend to use our weekly officer to certify that our records were in working order and reliable.
And that's not the issue, Judge. She's trying to avoid the issue by pointing to weekly simulator tests, which is not the issue at all. There's no scandal with weekly simulator tests.
Mr. Mays,
and that's not why the Michigan State Police took every single DataMaster out of service almost 12 months ago.
You have not identified a problem with our DataMaster at all in your brief. In your motion.
And I think that's one of the issues we've got is, from my understanding of the way this whole thing went down, is the state police knew they had a potential problem, so they yanked all the DataMasters. But unless there's some specific showing that the Huron Township DataMaster is problematic, you've just got a lot of maybe.
No, Judge. This is under Krulikowski. This is a foundational issue. The prosecutor needs to establish that the machine was in proper working order. That's one of the foundations for the admissibility of it. In order to prove that the test was relevant and reliable, she needs to meet those foundational factors under Krulikowski. She's indicating in her motion response that these are business records and that the witnesses are so reliable, so inherently reliable, that the records themselves should just simply be admissible under the business records exception to the hearsay rule. And that's simply not true. The problem with that argument is we know that this witness is not credible at all. This witness is being charged with felonies. Actually, Mr. Clark's case, the other person from Intoximeters was just sentenced to 9 months in jail as a result of his engagement in the fraud. Now, Mr. Clark's case was dismissed, I believe, last week on jurisdictional grounds, but we have every reason to believe that he's still under investigation, that they're going to bring these charges anew in a different jurisdiction. That said, Judge, I mean, 9 months is what the other fella got for his involvement in the scandal. The problem is that when you look to the business records exception that the prosecutor intends to rely upon, that exception does not apply when you've got a person that's engaged in malfeasance and misfeasance. And I've got a case on that. Solomon versus Schul, 435 Mich 104, 1990, quote, the circumstantial probability of trustworthiness arose from the fact that under certain circumstances, the trustworthiness of the source of information and the accuracy of a recording is sufficiently great to be the equivalent of a statement given under the ideal conditions of oath, cross-examination, and in the presence of the trier of fact, citing 5 Wigmore on the rules of evidence. It is under the circumstantial probability of trustworthiness principle, and to a lesser extent, the necessity principle, that the traditional common law business records exception was premised. Specifically, the circumstantial probability of trustworthiness of traditional business records is sufficiently great to justify an exception to the hearsay rule because of the habit, the detection of errors, and an employer's reliance on the result. Habit or the regular and systematic preservation of information by its very nature calls for accuracy. Consequently, errors or unintentional misstatements are almost certain to be detected. Furthermore, if the employee is preparing the record, is under a duty to do so, or is aware of the employer's general reliance on the accuracy of the records, a powerful motivation to be accurate is supplied. None of these factors are present in the immediate case where actual fraud has been uncovered by the quote unquote employer, and there was powerful motivation to be accurate that Mr. Clark completely ignored because he's being criminally prosecuted. The prosecutor also relies upon a recent Court of Appeals decision, Footnote, that indicates that the right of confrontation doesn't apply to this 120-day person, but in that very decision, they talk at length about Mr. Geyer's reliability. We obviously don't have Mr. Geyer's reliability. He's the person that used to perform 120-day certifications and is instead replaced by Mr. Clark, who's being criminally prosecuted. That decision is also on appeal to the Michigan Supreme Court at this time. So all told, Judge, the prosecutor under Tippold is required to establish the 120-day certifications were done. And maybe I should back up. In my brief, I've tried to explain the importance of the 120-day calibrations and certifications.
Let me
and
stop
what it
you.
all entails.
Let me stop you.
Yes.
So far, I hear a bunch of legal arguments. I don't see any need for a witness. So what witness is going to help me determine whether or not the prosecutor's got a duty to get past that 120 days?
Currently, right now, Judge, what Mr. Fondren is trying to do is he's going through the electronic evidence that's available in these DataMasters. He's going through it line by line to ascertain whether or not the machine might have been working properly on a particular day. And what he's found while doing this review, for example, in Traverse City, he found that there were entries being made by other officers with using passwords to take an out-of-service device and placing it back into service. As a result of that, as recently as just December 11th, 2020, just a few days ago, the Traverse City prosecutors had to send out a Brady letter to the defense bar indicating that on specific dates, they've uncovered these DataMaster problems in their jurisdiction that were resulting from the misuse of passwords. Now, Mr. Fondren's attempts to establish the relevance and reliability of a particular breath test, I mean, what he's doing is he's breaking down that electronic evidence, and we're finding more errors on top of that. Now, Judge, the reason why the 120-day is so important is because it actually calibrates the device. It checks the simulation of the device. It also checks to make sure that other areas of the device are working, such as the RFI detector and the barometric pressure. This is the essential way that the machine works, and that's what the 120-day is for. The weekly simulator logs don't establish that. The weekly simulator logs simply establish whether or not there has been drift. The local officers from Huron Township, by looking at the simulator logs, their weekly simulator logs, cannot tell us if the machine was working properly on any of those days. They're simply running a dry gas simulator. So they're going to look at this dry gas simulator, which can absolutely fool them into believing that the machine was working properly on that date, because the 120-day guy, Mr. Clark, did not do his job properly or allowed an out-of-service device to be placed back into service without correcting the deficiencies, which is part of the problem of what happened in Huron Township, was that the testing was not done correctly by Mr. Clark, and it wasn't noted anywhere on these logs. The Huron Township officers would have no idea that this actually happened.
Let me back you up, Mr. Mays. How do we know that Mr. Clark did not properly do the testing on the Huron Township instrument?
That is included in a Michigan State Police report dated June 4th, 2020. It's in a spreadsheet that was provided in connection with that report, indicating all the problems that they found involving these two intoximeter people. And just going through some of these things.
Well, just hold on. Let me ask
Yes.
you a specific question. Does that report cover individual DataMaster instruments?
It does.
Okay, and the Huron Township instrument is specifically covered in the report.
It is.
Okay, go ahead.
So some of the errors that were committed by these two. No
No,
documentation.
no. Oh, hold on. I don't care what they did
Okay,
in
that's fine.
Addison, Michigan. I just want to know what's been determined by the state police as it applies to the machine or the instrument that's a subject of these cases.
Understood, Judge. That's the problem, though. Without access to the electronic data, I can't look at that. All that I can do
Okay.
is look at what the Michigan State Police are willing to tell me. They haven't gone through, and I know that Mr. Fondren has not been called down to Huron Township to actually review this particular device or to review the individual logs. This is just what the Michigan State Police found in their cursory review. They found that Huron Township was out of compliance.
Right. Yeah, but what they found, specifically, what did they find, Michigan State Police find as to the Huron device?
They found that Mr. Clark did not properly do a wet bath simulator that was outside the specified range, and he did no additional testing.
Okay, so what you're telling me, if I understand correctly, is Fondren is actually going instrument by instrument and opening them up and finding out what's going on in individual instruments, but he has not been to Huron Township to address their specific instrument.
He's actually receiving
Correct.
this. He's actually receiving this electronic information remotely and going through the actual.
Okay. All right, and is that something that the state police have set up, so he's going to eventually get to all of them? Or does he
No.
have to be invited in by Huron Township because that instrument's in their possession?
He needs to be invited in.
Okay, all right. And is there any thought of doing that, if you know, Ms. Foley-Carter?
I'm not familiar with that. I know Sergeant York from MSP went to the department and certified that our DataMaster was in working order and got it back online after it was taken offline. And that's as far as I know that was required.
That's interesting that she should mention that too, Judge, because I pulled the January 2020 logs. And looking at the January 2020 logs from Huron Township, it doesn't even indicate that it was ever taken out of service. And we know that it was taken out of service.
Is Sergeant York the new Mr. Clark doing the testing?
No, Your Honor, he was just required to go department by department to get these machines back online.
Without doing the 120-day testing?
It was as if it was a new machine.
Okay. Okay. So I'm going back to my original question, Mr. Mays. What's your expert going to tell me? Going to help me with the facts. What's your expert going to tell me?
He needs access to
Just
the
broad
data.
strokes.
No, he needs access to the data before he'll come to an opinion. In the Traverse City case, it wasn't until this information was disclosed to the defense that he found all the problems, the accessibility through passwords and whatnot else that couldn't have been done by Mr. Clark or the other one because they weren't there.
Ms. Foley-Carter, do you have control over that information to share even if we want to?
I don't believe so, Your Honor.
Huron Township Police Department has exclusive control over this.
Okay. All right. Well, then here, I'm still confused, Mr. Mays. It sounds to me like we can have a discussion about everything you're talking about. I mean, if I buy your arguments, I don't need to hear a witness. Am I right?
No, I disagree.
Because what I'm hearing from you is because the 120-day testing wasn't done,
yeah,
there is no reliability to the instrument and everything should be thrown out during that time period.
If that's your
I
position,
mean, isn't
yes,
that
I
your
agree.
argument?
It is.
Okay. So why don't we have our motion and then as things develop, if we need to take testimony from witnesses, we'll do that.
Okay.
Because to me, I'm hearing a lot of legal arguments here and I don't see a factual witness helping me out with that.
Sure.
Ms. Foley-Carter?
That's fine, Your Honor.
All right. Let the games begin.
Very good, Judge. So on January 10th, actually, you know, Judge, I take that back. I told you earlier that Ms. Trombley's test was done shortly before the problem was found, and it wasn't. It was actually found 2 days after the problem. Now, Mr. Dickeroff was arrested in October of 2019 and tested on the Huron Township DataMaster. Ms. Trombley was arrested on January 12, 2020. That's an important date because on January 10th, the Michigan State Police announced that was when the agency said they were taking over the DataMaster testing statewide. They sent out a letter to all the prosecutors' offices saying this letter is to notify you that a stop order on the current vendor's contract was issued January 7th, 2020 due to performance-related issues. Now, I should note, Judge, what we have found is that the Michigan State Police knew about this problem for almost a year, maybe even longer, before they actually reported it to the prosecutors and subsequently the defense bar. On January 13, mere hours after Ms. Trombley had provided her breath test, the Michigan State Police took all 203 DataMasters out of service across the state because they knew of explicit fraud, malfeasance committed by two of the Intoximeter people, and they suspected more. They suspected that the 120-day tests and the various things that are done under those 120-day tests had not been performed at all in some cases, were being performed incorrectly in many cases, and that they had released the passwords to individual police officers who were not authorized to have these passwords, and that these officers were then taking out of service devices that were known to be faulty, known not to be working properly, and putting them back into service. On January 16th, 2020, the Michigan State Police announced that they had opened a criminal investigation. Now, I can't emphasize enough the magnitude of the scandal. There's been testimony up in Lansing before the Senate from the Michigan State Police addressing this issue. It's been widely covered by all the major news outlets, and the public generally understands at this point there was a major problem with breath testing. Now, if we go back to when Sergeant Perry Curtis was involved in the DataMaster, the implementation of the DataMaster DMT, which is the newer DataMaster as opposed to the back DataMaster that it replaced. Sergeant Perry Curtis explicitly ordered this device to be produced then by the manufacturer out of Ohio, National Patent Analytics Systems, and intentionally disabled the memory function. He also intentionally disabled the breath profile screen, which would provide us with what the breathing patterns for the subject were, and also disabled some of the other, I'm sorry, I'm losing track here. The breath profile, the breath pattern, which shows us how the person was blowing, and an alcohol graph that correlates to that to show us at what point they were blowing a specific number. The only reason for disabling this was because it provided access to valuable information to the defense. The Huron Township prosecutor has not responded to any of these allegations, simply saying that no response is required. These are facts that I can establish through my expert. And I mean, if we need to subpoena Sergeant Perry Curtis to answer to why he had these things disabled. But the bottom line is that we have what is essentially a great new breath testing device that was largely disabled and crippled by Sergeant Perry Curtis. Sergeant Perry Curtis then retired, and DataMaster was sold to a different company, which Intoximeters. Intoximeters assumed the contract that National Patent Analytics Systems had maintained for almost 20 years, maybe even longer, whereby they had provided the 120-day maintenance to the DataMaster through their various representatives across the state. Intoximeters took over that part of the contract and provided their own, well, basically our class 4 operators, but through the private company, to maintain these devices. They're required under the administrative rules to go through every 120 days and to do a variety of functions, including several different wet bath simulators, an RFI check, and now with the new dry gas simulators, they're required to check the barometric pressure, because what we don't understand about the DataMaster's general public is that these devices have to be calibrated based upon their altitude and barometric pressure. Now, there is a dry gas simulator which has replaced the wet bath simulators that police officers used to use 10, 15 years ago. A wet bath simulator actually checks to see, based upon an external source, if the machine is reading in compliance with what we expect it to. And the court might recall on a few occasions, we've seen problems with wet bath simulators where crazy numbers are being provided when the officer blows into what's known to be an 08 or a 10 standard at the time, having the device blow 17s and 18s, and no reason why. They take the device out of service because we know that in that wet bath simulator, it's an 08 solution or a 0.10 solution. By replacing this with dry gas simulators, the officers are no longer required to do these weekly simulator tests. We no longer know that we have this external standard of a 0.08 solution or a 0.10 solution. Instead, there's simply a tank that's attached to the DataMaster DMT that internally tells us whether or not it's working properly. Unfortunately, with the 120-day operators, we don't know if it's working properly. All that we know is that it's working in conformity with what we expect it to see, but we don't know if that's actually accurate because it's all one integral unit. Thus, on the Huron Township DataMaster logs, we see that Andrew Clark did not perform a test correctly. There's no notations on Huron Township logs, as I indicated earlier. Eventually,
let me stop you there, Mr. Mays. Hold on,
Yes.
Let me stop you there.
Yes.
How do we know from the log that Mr. Clark did not perform the test correctly? I'm sure it doesn't say such and such a date, Clark there did the test improperly.
No, it actually says that he did it properly under his own signature.
So how do we know that he did it incorrectly on that date, on that instrument?
I do not know. I don't know.
Okay,
Michigan State Police
I just-
uncovered this, and it's just a notation in their logs. No further
Yeah,
explanation.
does the state police say that that particular test by Clark on that particular Huron Township instrument was faulty?
Yeah, they do.
Okay,
And
go
they
ahead.
did no further testing, but they don't offer any explanation as to how they found it. I should probably note, Judge, that this report, there's a problem with this report, so I don't want the court to adopt this report as if it's gospel. Mr. Fondren, I'm sorry, I lost it. Somewhere in my stack of documents here. Here we go. Mr. Fondren is now the person who's taken over as a somewhat different position from Sergeant Perry Curtis. He was brought in as the technical director for breath testing, which is slightly different from what Sergeant Perry Curtis, what his title was and what his job function was back when he was employed by the Michigan State Police. But Mr. Fondren came onto the scene, and after he was aware of this problem for an extended period of time, and after the Michigan State Police had taken all 203 DataMasters out of service, he composed a team. Now, I should mention Mr. Fondren, his roots are down in Texas, where he was involved in breath testing down in Texas. He was brought on to improve the Michigan DataMaster program because I hate to quote Sergeant Perry Curtis. This was a conversation between him and me many years ago. He said, William, this entire program is held together with rubber bands, and sooner or later, one of them is going to break. And he retired. Mr. Fondren was brought in, and he will acknowledge that he was brought in to fix and bring up to task the Michigan DataMaster program. Now, after the scandal, of course, this is just horrific for him. He places together a team to investigate what the various problems with the DataMaster were. It consists of Randall Beatty from the Texas Department of Public Safety, Mark Cowan, Texas Department of Public Safety, Robert Sears, South Carolina Law Enforcement Division. This is the team that he compiled to look at the Michigan DataMaster. In other words, he has roots with these people. He has ties to these people. He brought these people in. They're very friendly to Mr. Fondren. But despite that, they found that there were missing technician signatures, limited or no documentation supporting the need for a calibration, incorrect lot numbers for dry gas simulators, improper forensic corrections, wet bath simulator solutions results outside of the approved tolerances, missing records regarding diagnostic records checks and radio frequency interference checks, instrument location with blank or handwritten notes that should not be handwritten. Significant errors were noted in the accuracy check with no corrective action taken. For example, the filter wheel error or an interference detected or a standard out of range. And instruments were removed or returned to service with no supporting documentation. They also found, as part of their review, Judge, that there were large barometric pressure changes over a matter of minutes during a 120-day certification inspection conducted at testing facilities. There were changes in the location descriptions by the 120-day inspectors. Electronic records in the XML file format retrieved from instruments conclusively identifying tests conducted on different instruments. And alteration of original test reports that were actually submitted by these individuals to the Michigan State Police as evidence that they had done the tests. In one case, they literally cut, copied, and pasted some paper out and pasted it over DataMaster tickets to make it look like they had done this test. So Mr. Fondren is now faced with a real problem, Judge, at this point back in January. And lo and behold, as I indicated, these people, these folks that he had selected, went to the XML files, which are the electronic records that Sergeant Perry Curtis had told National Patent Analytics Systems to disable years ago. Now, you can't tell a whole lot from these raw data files, but you can tell when, like, for example, an RFI detection simulator is run on the machine. And so he's gone through these records to try and pick out every time an RFI test was run on the device, because the local officers don't have the ability to do that. And by highlighting those, he's then able to determine whether or not Mr. Clark actually performed the tests on the dates that he claims that he had done them. In many instances, he had not done the tests on the dates that he had claimed he had done them. The problem, though, Judge, is that the 120-day testing is all, like I said earlier, designed to ensure that the machine isn't just working correctly, but is working at all, and isn't producing wildly erroneous results. This is the person that the prosecutor needs in order to be able to establish whether or not the device was working at all and working properly.
Let me stop you there.
Yes.
Let me stop you there, because that's kind of the crux, one of the crux main points that you're hanging your hat on, correct?
Yes.
Okay, I want to give Madam Prosecutor a chance to respond to that.
To what, Your Honor? To the 120-day?
Yeah, the importance of
Again,
that testing to set the basis.
Your Honor, I don't believe it's a foundational problem, like defendant said. Defense has failed to enunciate a single problem that occurred with the two cases in front of us. Even if there were some sort of perceived problem, say with the 120-day test, it goes to the weight, not the admissibility of the evidence.
Respond to that, Mr. Mays. Why is it not a weight question rather than admissibility?
Sure. The thing is, Judge, this weight versus admissibility issue has been brought up so many times. You know that. When there is a technical error, like under Rexford or Wojciechowski, that's something that obviously does not require suppression. In Wojciechowski, there were two officers in the room. The defense attorney filed a motion saying this officer did not properly observe Mr. Wojciechowski for 15 continuous minutes.
Mr. Mays, stop you.
Yeah.
Hold on. Sorry.
No problem.
Al just got a call from Rob Young. He's in the room waiting because nobody's come in.
Oh, yeah, he is.
Okay.
Right. I'm bringing Mr. Young in.
Okay.
All right, go ahead, Mr. Mays.
Thank you very much, Your Honor. In Wojciechowski, the defense attorney filed a motion indicating that the officer had not properly observed Mr. Wojciechowski for 15 continuous minutes in violation of the administrative rule. What the defense attorney failed to mention was that there was another officer watching Mr. Wojciechowski, and the time that the officer did not observe Mr. Wojciechowski is when the officer turned his back to look at the clock on the wall to ensure that 15 minutes had passed. So it was during those mere seconds that the defense attorney filed this motion indicating he didn't observe Mr. Wojciechowski for 15 uninterrupted minutes. And the Court of Appeals, of course, drew out the facts and said, there was another officer there. He only turned his back for a moment to check the clock. That is a technical violation of the administrative rules. In Rexford, the same defense attorney filed a motion indicating that Mr. Rexford's breath test should be thrown out because the officers had not performed the weekly wet bath simulator tests that we had talked about earlier. What he failed to mention is that those tests had not been done, that they had missed a week or two, 3 or 4 months before Mr. Rexford test was actually done. And the Court of Appeals said, well, maybe it would apply to somebody during that time frame, but certainly not to Mr. Rexford case, where the tests were all being done in compliance at that time. Now, interestingly enough, Judge, the prosecutor here in Huron Township has relied upon an unpublished case from the Michigan Court of Appeals, City of Plymouth versus Kanka, K-A-N-K-A, which she's attached a copy of to her motion response. And in that one, she indicates that the holding of this case supports the idea that this is merely a technical violation, that we have these two individuals charged with multiple counts of fraud. In that case, as the prosecutor cites it, the testing instrument, the DataMaster, had not been verified for 11 of the 33 weeks preceding Mr. Kanka's breath test. Okay, but then you read on to the next paragraph, because the prosecutor didn't even contest this. Despite these uncontested allegations, defendant offered no evidence that the instrument used to test his breath was inaccurate. Suppression of the test result is only required when the violation of the administrative rules calls into question the accuracy of the test. Here, the instrument was tested on the same day as the defendant was tested, March 5th, 2000, 21 hours later, and proved accurate. The instrument was tested 9 days before defendant's test, as well as for several months before and after defendant's test, including 6 times in February and 4 times in March of 2000, and the results were always within acceptable limits. In other words, there was a technical violation, some indefinite time in the past before Mr. Kanka had been tested. Now, this is just in regards to the weekly simulator test, though, Judge. The heart of a DataMaster and its accuracy is all about the 120-day checks. And that's the problem. We don't even know if this machine was properly in service or out of service, and we know that the person who was supposedly in charge of this engaged in fraud. He engaged in criminal conduct, he engaged in malfeasance as well as misfeasance regarding his duties. And the prosecutor's only response to that is we should be allowed to introduce these logs through the business records exception. Again, however, the business records exception only applies when the underlying documents are so trustworthy that we can't help but trust the accuracy of those documents. And in that Foley-Carter decision that the prosecutor relies upon, I would specifically refer the court to page 2 of that decision, where it says, in September 2017 and December 2017, Marvin Geyer, the Class 4 operator who conducted the 120-day tests on the DataMaster, inspected the particular machine used on defendant, verified its accuracy, and certified that it was in proper working order, which is reflected in the DataMaster logs. There's no issue regarding Mr. Geyer's administration of the 120-day test. And presumably those tests were actually done and done properly by Mr. Geyer. But here we know that Mr. Clark, who replaced Mr. Geyer, he has no trustworthiness, and he's been charged with crimes. So, Judge, let me go back to my argument. In the Tipple decision, the Court of Appeals held a reading of the administrative rules with respect to the administration of breath tests indicates that their purpose is to ensure the accuracy of those tests. Failure to meet any of the foundational requirements will preclude the use of those tests. Although the exclusion of evidence is not necessarily the appropriate remedy for every violation of the administrative rules, when the administrative rules concerning the administration of breath tests has not been complied with, the accuracy of those tests is sufficiently questionable so as to preclude the test from being admitted into evidence. And Judge, I'll go a step further. I think the way that the Michigan courts have treated this since Krulikowski is actually wrong. It's always the burden of the proponent of the evidence to establish relevance and reliability. It's the prosecutor's obligation to establish that the machine in this particular case was working properly on the specific date pertaining to the specific individual defendant that tests on the DataMaster. And if the prosecutor, as the proponent of the evidence, can't do that, the test doesn't come in. So when we argue weight versus admissibility, I'll be the first to agree that there are certainly going to be silly arguments that are raised by silly defense attorneys trying to avoid the admissibility of a DataMaster, and they point to mere technical violations. When we're talking about whether or not a machine is working properly, however, and it's tainted by fraud and malfeasance, then the prosecutor has a problem, because I believe that we should be allowed to cross-examine Mr. Clark at an evidentiary hearing or otherwise to find out what he did. The fact that the Michigan State Police found that there was at least some evidence that Mr. Clark hadn't properly done his job down in Huron Township, and that the Huron Township prosecutor isn't even aware of that, nor the individual officers, that's very problematic. Judge, the confrontation issue, I've outlined it in my motion. I think that this is a real problem when you've got a person that's actively being prosecuted by different prosecutors, and you've got a different prosecutor in the different room saying, but trust this guy, his signature on a document is trustworthy. That's a problem. But that Foltnot decision is on appeal to the Michigan Supreme Court from the Court of Appeals decision, which actually did not address the ongoing problem that we've had with the DataMaster DMTs with this fraud issue. They simply looked at Mr. Geyer and said that he's a credible witness. And you know what? I don't have any reason to disagree with the Court of Appeals regarding Mr. Geyer, but I certainly have every reason, so should this court, regarding Mr. Clark.
Has Clark testified anywhere, Mr. Mays?
He has not, Judge. And actually, that was part of the scandal that erupted regarding the disclosure of some of the text messages. First off, Mr. Clark and the other defendant were both actively avoiding subpoenas from the defense bar. And it turned out that Mr. Fondren and others at the Michigan State Police were actively encouraging them to not testify and to avoid service of these subpoenas. And that led to an order that Mr. Fondren and others disclosed their text messages from their cell phones that they were using to communicate on these issues. And it came out that Mr. Fondren had actually been doing this. As a result of that, an officer from the Michigan State Police was reassigned from the breath testing unit, as detailed in my motion, to a different area of the Michigan State Police. So the scandal doesn't even just end with the breath testing scandal from last year. It continues with the problems that have come about with interference, let's say, with the interference by the Michigan State Police on getting full disclosure on what these issues are and full disclosure regarding what the problems with these machines are. So for example, in Traverse City, Mr. Fondren testified very persuasively that there was absolutely nothing wrong with the breath testing device in Traverse City. And then the defense attorney started cross-examining him with the help of the expert witness that had been going through the XML files. And Mr. Fondren found that he could not justify several entries that he had just basically ignored that showed that the machine had been taken out of service automatically by the device itself and then placed back into service, and he had no explanation as to how that was done, thus generating that December 11th notice from the prosecutors in Traverse City, letting the defense bar know that this is Brady material and we have to disclose this to y'all.
All right. Ms. Foley-Carter, response.
Your Honor, again, I did not hear anything regarding ARM machines, particularly in this case, that calls into the question the accuracy of the DataMaster results in either Mr. Dickeroff's case or in Ms. Tromley's case. I know defense counsel likes to talk about Traverse City and malfeasance in Oakland County, but again, he hasn't produced any problems with our DataMaster machine as to these two cases.
So you don't agree with what he's saying, that the state police issued a report and said they found problems with your instrument and the Mr. Clark's testing thereof?
I'm not aware of that, Your Honor.
Okay, anything else?
No, Your Honor.
Mr. Mays, Mr. Duncan, Mr. Young, anybody got anything else?
Well, Judge, I would just like to add, if I may, Mr. Mays has a lot of knowledge, obviously, and I was listening. And when just as an elementary point of law, as I'm listening, I'm hearing that these DataMasters were all taken out of service on January 10th because of problems which included fraud and malfeasance by the people who were supposedly running these 120-day tests. So every one of these machines, including the machines that we're talking about with our clients, were taken out of service. Then I hear Mr. Mays say that there was an indication that there were some problems within Huron Township. It's a major problem, I think, for the prosecutor when they want to introduce technical evidence of a crime, and the person who's in charge of running the most important test on this device is accused of a crime that specifically relates to the operation of that test and includes fraud. And now there's people going to jail. And this isn't, from what I can tell, this isn't speculation. This is a fact. And this is what the state police have said. So for the prosecutor to introduce any test results during this time period with this kind of a background, certainly wouldn't go to the weight of the evidence, because we'd have to have a trial just on this. I would think that the prosecutor would want to come to the position and to the court with sound evidence that the test results that she's trying to prove are accurate, knowing that the background would indicate that there's a high probability that there may be serious problems. Thank you, Judge.
You're welcome. Anyone else?
Judge Robert Young here. Apparently, I apologize to the court for being a little disheveled here. We had a COVID incident that happened, and when I came back to the office, they were fumigating, so I had to grab stuff and run to a different area.
No
I
problem.
don't have anything in front of me. But when we spoke earlier, I don't know, this month or late last month, it was clear to me that these motions were similar in nature, because this involved the Huron Township Police Department. And you know as well as I do, and everyone else knows, Sumter Township utilizes that facility for just the matters that we're discussing. And so I received the motion by Mr. Duncan a couple of weeks ago, didn't have time to respond to it, but it was clear to me that the issues presented to the court, argued by Mr. Mays and Ms. Foley, were similar, if not identical, other than dates or names of the defendants. So that's why I'm just joining in the response on behalf of Sumter Township with that which was filed by Ms. Foley. So
Thank
I
you.
don't have, I'm sorry.
I said thank you.
All right.
Okay. I think as I read through these briefs, one of the things that bothered me the most about this is it seems like the state police have a major problem and then they spend a year trying to hide it instead of fix it. Actually more than a year, I think. And you know, there's already enough distrust in the public about what we do in the system. That's offensive to me. And Ms. Foley-Carter, I don't see any way we can get past the foundational question, which is the 120-day test. You're not going to get anybody to testify on it. You know, there's no way I can see that Clark is going to not show up, even if he shows up, and not just claim the fifth. I'm granting the motion on all three files.
Thank you, Judge.
I think the language from Tipple, Mr. Mays, rang pretty loud.
Thank you very much.
Anything by way of clarification for the record, attorney types?
No, Judge.
As I understand the court's ruling, the breathalyzer results are suppressed then, is what we're talking about.
Yes, sir.
Okay.
And Mr. Young, I've got another item for you that doesn't have anything to do with any of these other folks.
That's accurate.
All right.
Should we log off,
Mr.
Judge?
Young? Yeah, you can log off. Thank you, folks.
Thank you very much.
Thank you, Judge.